All right, welcome this morning to Senate Education. We have one bill today to consider. We're still waiting for a couple of members to filter in, and they will undoubtedly be here. But we'll go ahead and get started because we do have things to do today. So with that, let's go ahead and call the roll.
This is roll call for Senate Education, February 27th. Senator Brennan,
Excused?
Senator Olson,
Here.
Senator Rothfuss,
Here.
Senator Scott,
Here.
Chairwoman Schuler.
Excused.
You have a quorum.
All right, and the first bill that we're going to consider is House Bill 159, Safeguarding Personal Expression at K through 12 Schools. This is brought to us by Representative Lean. Welcome to Senate Education. I don't know, you tell us about this bill and then walk us through it.
Good morning, Mr. Chairman, Senators. Thank you for having me today. This bill is first an equal treatment bill, and I think that's really important that we understand. This bill aims to codify protections for student speech and expressions in public schools with a strong emphasis on preventing discrimination against religious, political, and ideological viewpoints. It amends the Wyoming Governmental Claims Act to waive sovereign immunity for violations, creating a private cause of action with remedies including declaratory relief, injunctions, monetary damages, attorney's fees, and a 2-year statute of limitations where each day of the violation counts as a new accrual. This is not new legislation. Under the Clinton administration, there was a guidance document sent to the Department of Education and distributed across our great country. It protected prayer and freedom of speech in school. It passed, this document was reaffirmed under the Obama administration, and just this month, it was reaffirmed under the Trump administration. This bill codifies the Clinton administration directive reaffirmed by bipartisan support and later administrations. It only applies to K through 12 public education schools, no private schools. They are excluded for obvious reasons. It prohibits discrimination or penalties against students for expressing religious, political, or ideological views in the same manner as other speech. This extends to class discussions, homework, and artwork, to name a few things. Organizing clubs and gatherings, and wearing message-bearing clothing and accessories. Schools cannot discriminate against clubs based on their viewpoints, internal requirements. Just as schools may want a Chapter USA club, they could also have an LGBTQ club. This protects both spectrums on either side. At least 10 states have similar religious liberties and viewpoint anti-discrimination acts. It's often modeled after federal guidelines. I want to talk about fight words. This came up in the House quite a bit. The fight words, or what you would refer to as anti-bullying and harassment policies. School districts already have policies for these in place. In my district, they're 5370 and 5440. And this just codifies into law those practices. It does not give students the opportunity to be disruptive, and it does not give them the privilege to say vulgar or harassing, bullying things. So I just want to make sure that we talk about that. Fight words are things that are insulting or provoking. They provoke immediate violence, which are unprotected. And school policies typically already have broader rules on disruptive threats, harassment, bullying, fighting, and student expression. And so as long as those policies are not violating First Amendment speech, this just codifies into law policies that school districts already have. And then I'd be happy to walk you through the legislation. I gave you a brief overview on what it's doing. We'll start with the liability to student waiver, the governmental entity. So I want you to know that there would be the same process that takes place now when a student wants to start a club would still be the same process that took place. This just protects the open discussion on assignments, artwork, or classrooms. So an instance would be if somebody was pro-life and they were taught that within their home, and an assignment was open for, say, to write on a hot topic, an immediate current event going on in our state, that a student could not be punished for writing a pro-life paper versus writing a paper to uphold the Supreme Court's open abortion ruling. That's what this legislation does. And then it does give parents recourse if the school district does impose on their First Amendment rights. And it gives us it gives parents the opportunity to use the district courts instead of the federal courts, because right now you would have to prove your case in a federal court on your First Amendment speech and not in front of a district court. This legislation walks you through expressions of religious or political ideological viewpoints, expressing what those look like, and organizing religious, political, and ideological gatherings before school, after school. So things like prayer at the flagpole, or having a club after school, or over in our district, they call it either Mustangs Connections or Trojan Connections in that homeroom period time. There are some clubs that meet then, like the Science Club. This just makes sure that the ideological viewpoints coming from K through 12 students that are practiced within their home are not being punished at home, that we're creating constructive thinkers, and we're allowing all ideological viewpoints to be had. And with that, I'll stand for any questions.
Representative Ling, could you walk us through the bill? It's pretty substantive, so I think it would be helpful to look at we're creating 2 new statutes in law, 1-39-125 and 21-3-601. There's a lot going on here, so I think we've got the time, and it would be helpful to just go through it.
So 1-39-125, the liability in student expressions in schools. It's the government entity is liable for damages. And this is where the school waives immunity under the 11th Amendment of the United States Constitution. And it allows for lawsuits to be able to be filed if a school violates this act and is not immune from the suit or liability of the violation. And then,
Yes, Senator Scott.
Mr. Chairman, on that provision, it's page 2, lines 6 through 11. Why do we need that? Why aren't our state courts perfectly adequate for this purpose?
Representative Ling.
Mr. Chairman, Senator Scott, what has been found is that as there have been challenges around the country, it's harder to get into a federal court, and it's more costly, again, for the school district and for the families that are trying to protect their First Amendment rights. And so giving our courts the ability to handle this at the local level, and I believe that our judges are adequately prepared here in Wyoming to be able to do that.
Mr. Chairman.
Please, Senator Scott, go ahead.
Mr. Chairman, so we could take out lines 6 through 11 perfectly well, and because that's what allows the going to federal court. And Mr. Chairman, if our state courts are perfectly adequate, would make sense to me to say, book the federal courts through the federal courts, and we don't need to mess with them.
Mr. Chairman.
Please, Representative Ling.
My thought on that would be that if we don't have this law, the only recourse for a student is to go through the federal courts. And so, but if we have this law, then the state courts would be adequate. That would be my thought to that.
Yes, Senator Rothfuss.
Thank you, Mr. Chairman. Representative, I don't understand that, because B seems to say exactly the opposite. B seems to be giving access to federal courts in a circumstance where otherwise, based on this law, it would go to state courts. So I'm reading the opposite of what you're saying.
Representative Ling.
Mr. Chairman, I am not a lawyer, but I do have one online. And if I could defer to him, I would let him answer that question.
We'll save that question for online testimony. That's fine. Okay, so Article 6, 21-3-601.
Under this section, it protects students' free speech, expression, and definitions. It also offers remedies. It defines school. It defines a student that knows, and then under section B, it says, no student shall be discriminated against for or penalized by a school for engaging in religious, political, or ideological speech or expressing a religious, political, or ideological viewpoint in the same time, place, and manner, the same extent, and other similar situated students may engage in speech or express views in the school. And I think that portion is very important, that this is not for disruption. It's for during class time when the teacher opens up the assignment or opens up the classroom discussion, that they, at that time, the student would be able to share their viewpoint. But at no time does this authorize a student to be able to just have outbursts in the middle of class time.
Well, that's not exactly what this paragraph says. It says wherever the time, place, and manner is occurring doesn't necessarily mean that it can't be in the middle of a class or outside of a class or in the hallway. It appears to say that it can. I'm really confused by the language. It appears to say it can occur anywhere, and then what I'm really not understanding is the same extent that other similarly situated students may engage in speech or express views at school. I'm not sure what's meant by similarly situated students. Can you help me with that?
Mr. Chairman, this would be, say, we're in a biology class and we're talking about from conception to birth, and the teacher opens it up to talk about ideological viewpoints on the fetus and when life begins. That would be similarly situated students that are all in a class having a discussion with the teacher.
Okay, thank you.
From there, we move on to how the student may engage in protected speech or expressions in schools, including but not limiting to, and then it walks us through expressing those religious, political, and ideological viewpoints through homework assignments, artwork, presentations, other written or oral assignments without discrimination. Academic penalty based on religious, political, or ideological content of the student's submission. I believe that that's all.
So Representative
Straightforward.
Lean, on page 4, Romanet 3, this provision would allow students to organize for religious, political, or ideological purposes before school. That seems fine. After school, that seems fine, but during instructional time, why are we going to allow the organization during instructional time? So a kid could just form a group or a protest in the middle of the school
Mr. Chairman.
during class?
Forming a protest is not the intent here. The intent would be such as our school district has the homerooms, and there are clubs like the science club that do gather over that hour. That if you wanted to also gather over your lunch hour, that it would give them the opportunity to be able to do that as well.
But this is instructional time. That's not a lunch hour. Instructional time is the time in the classroom. I understand what you want this language to do, but it may have unintended consequences, as it allows a student to organize a political gathering during instructional time. And I just want to understand why we think it's appropriate to disrupt the instructional time of the school for a political event.
The only event that comes to mind is when the protest happened here just a few days ago outside our Capitol, where teachers were letting their students out to attend those protests. That's the only thing that comes to mind for me.
That's not what happened. The students were advised by the administration that they could not leave the schools and they would be marked absent if they left the school. And to my understanding is they were all marked absent if they left the school. So currently, our law does not afford students the latitude to organize for political purposes during instructional time in the classroom, in the school. It's not permitted. So this is a pretty big shift in the way that we navigate First Amendment rights in our schools. And maybe we just take that part out of the bill. Maybe that's just too much.
Mr. Chairman, I'd be amenable to that.
Okay. All right. Please proceed.
And then moving forward, it talks about wearing clothing, accessories, jewelry. One thing that is important to know here is that this does not stop our school districts from having modesty standards, or from, say, somebody wants to wear a swastika coming in. The courts have already ruled that that is an antagonistic symbol and that it does create invoking harm. So school districts still have the ability to be able to take care of that situation properly.
Senator Rothfuss.
On that point, what about, as an example, head coverings, where we have certain religions that utilize various forms of head coverings, other religions do not. So a ban on head coverings, for example, based on this, I don't think it would appear discriminatory because everyone is banned from having head coverings, even though it specifically discriminates against certain faiths. What are your thoughts on that?
Representative Lane?
Mr. Chairman, Senator Rothfuss, I do see the safety concern that comes with that. I also question if we have the ability to take away that First Amendment right, that if that is their religion, then they believe that that is a sacred emblem for them, that we have the ability to take that away. And I would ask that you also follow up with the legal counsel on that question.
Okay, thank you.
From there, Mr. Chairman, I'll continue on. This gives us the ability to, Section D moves on to one or more students may organize in religious, political, and ideological clubs, and that they may be benefited the same across the spectrum. So it doesn't matter which side of the ideological spectrum you're on. If you can get with a sponsor within the school and the guidelines that are already set up on how to host a club or an organization within the school districts, that those are just awarded to everyone across the board, that there's no way to stand in the way of that. From there, I continue on through subsection F. There shall be no discrimination against any student club or organization because of, and then it lists out the religious, political, ideological viewpoints. Any requirement that the leaders of the club or organization affirm or adhere to the organization's sincerely held beliefs and comply with the organization's standard of conduct and furthers the club or organization's mission or purpose as defined by the student club or organization. And then section F, nothing in this section shall construe or prevent a school from prohibiting, limiting, or restricting expression of the First Amendment of the United States Constitution, and it does not protect the following: expression that is unwelcome or so severe, persuasive, or subjective and objectively offensive that a student is effectively denied equal access to educational opportunities or benefits provided by the school.
Senator Rothfuss?
Thank you, Mr. Chairman. Representative, when I read this for the first time, I was a little surprised by this language. The subjectively aspect of it caught me a little off guard because at that point, it basically says it's in the eye of the beholder as opposed to in the eye of some objective standard. And I don't understand how that then is implemented. It seems to me that at that point, if you have any individual in the school and they have strongly held personal beliefs and somebody else comes along and says something that is against their strongly held personal beliefs or otherwise something that is offensive to them, that this subjectively standard then basically means that they can condemn that behavior.
Representative Lane?
Thank you, Mr. Chairman. Thank you for your thoughts on that. I hadn't looked at it in that manner. And that would be my answer to that.
Okay.
So thank you. Thank you for your viewpoint. If it's okay with you, I'll continue on.
Please.
Conduct that intentionally, material, or subjectively disrupts the operations of the school or the expressive authority of another person. And that activity is occurring on the campus space reserved for that activity under the exclusive use or control of a particular student group of students, club, or organization. And then it continues on that any person, student, club, or organization that is harmed by the violation of this section, whose rights under this section are violated, shall have the cause of action in accordance with the following. And then we move into the person, club, or organization may seek declaratory, injunctive reliefs, monetary, reasonable attorney's fees, and cost of any other appropriate relief. And then it talks about $5,000 in damages. And nothing in this paragraph shall construe as limiting or prohibiting the court from awarding damages.
And Representative Lane, why do we have a minimum of $5,000 in damages? Why not just give the court discretion like we do 90% of the time at least?
There's other model, Mr. Chairman. There's other model legislation that this was built off of, and that was one piece of what was in their statutes. And so I just carried it over here. I'm not tied to the $5,000 attorney's fees. I would ask that that remain in the bill.
Okay, great.
And it moves through the penalty there. And it walks through the time limit of 2 years from the initial violation and no new accruals for a 2-year statute of limitations. And there we go to section 1-39-104, and we get to tort liabilities, and we just expand through statute 125, and then we get to the effective date.
Okay. So Representative Lean, when I first saw this bill, the first thing that came to my mind was I was questioning where exactly in Wyoming we're having issues. Can you give me some, I don't know, specific instances in Wyoming where we had violations of a student's First Amendment right, or you felt like the First Amendment didn't by itself wasn't applied properly or didn't go far enough?
Yes,
Just some
sir.
examples.
Yes, Mr. Chairman, and I have with me today Kylie Wall from Natrona County High School in Casper, Wyoming, and that is where this bill comes from. Her parents are my constituents and she lives within my district.
So she'll testify?
Yes, and she'd be happy to come up now if you'd like. I can have her come. She's here in the room.
We'll bring her up in time,
Okay.
but you don't have to answer that question if you don't have anything extra. We can just get the testimony from her. So,
That would be the prime example as to where
Okay.
this legislation stemmed from.
questions for Representative Lean? Any other questions? All right. Thank you, Representative Lean.
Thank you.
Any state agencies wishing to testify on this bill? Welcome, Mr. Shaner.
Good morning, Mr. Chairman, committee members. Dickie Shaner speaking on behalf of Superintendent Dagenfelder. Thank you for the comments already. I think that this is a difficult topic to draft legislation on with a lot of various constitutional and other jurisprudence issues. So with that, the superintendent wanted me to express her support for this this concept. She has been a advocate on the UW Board of Trustees for freedom of speech on campus and has been a part of the Freedom of Expression initiative at UW that has actually gained national recognition for being one of the best universities in the country that protects freedom of expression. And she thinks that this bill will help get us into a similar situation in the K-12. It'll help promote free speech in our public schools across the state.
Senator Rothfuss.
Thank you, Mr. Chairman. The curiosity I have really goes to the amendment to the Wyoming Government Claims Act and basically the unlimited liability to the state for a lawsuit in this space. Is that something that the superintendent supports?
Mr. Shaner.
Yeah, Mr. Chairman, through you, Senator Rothfuss, she supports some opportunity for redress in courts for an incident like this. Certainly, I think open to whatever this committee and the body decides on that. But something she struggles with very frequently is getting parent and constituent complaints and only being able to say, I'm sorry, there's nothing you can do other than talk to your local board. So she likes the possibility of saying, hey, maybe there's another avenue for you here with a law like this.
Thank you.
Mr. Shaner, one of the things that I've been hung up on is the instructional time provisions that appear throughout. Do you think there's any issue with limiting this so that it is something that is before school or after school, or is it really necessary to occur during instructional time?
Mr. Chairman, thank you. And my understanding with the Laramie 1 protest is the same as yours. I think that you could take it out or do something along the lines of during the school day, not during instructional time, to allow for those lunch period or recess or the sort of collaboration type period gatherings. But I agree. I think it's important that instructional time is not included.
And then, Mr. Shinner, you might be able to help me with this. Maybe somebody else will, I don't know, but I'm not an expert in educational law. But one reservation I have about this legislation is the ability to jump straight to a lawsuit. I don't know what administratively, what the process would look like, if that's different for every school or different for every district, but I would feel more comfortable if there were a process that if a student felt like their First Amendment right was infringed upon, that they could go through a process and the school would have an opportunity to remedy that before we jump straight to court. Can you help me understand what that might look like in a school?
Yeah, thank you, Mr. Chairman. I think that's a good point. If I remember correctly, the parental rights bill we passed a year or two ago around if there's a change in condition to the student's health or welfare or any sort of issue with that, there was a process to go through at the district level, and then it would go to court. And so I think there's a pretty good process in that bill already in statute that could be reflected in this bill too.
Okay, that's helpful. Any other questions for the Department of Education? All right, thank you, Mr. Shannon. Any other agencies wishing to testify on this bill? Associations? Any associations? You're all gathered in the corner over there. We'll start with you, Mr. Farmer. Welcome.
Thank you, Mr. Chairman. Brian Farmer, Wyoming School Boards Association. Mr. Chairman, when it comes to the freedom of expression, there really is nothing Wyoming law is going to be able to do to change the right that exists under the United States Constitution. The U.S. Constitution is the supreme law of the land. It sets out what is an individual's right. Ironically, Article 1, Section 20 of the Wyoming Constitution actually offers a broader right of freedom of speech and freedom of expression than under the United States Constitution. But under the U.S. Constitution, the place we really go to when it comes to student expression is a 1969 Supreme Court case called Tinker versus Des Moines. And in Tinker versus Des Moines, they laid out what is still the standard today, talking about how a student's rights are not shed at the schoolhouse door, and the student has the right of expression, but there are some reasonable limitations on that. Interestingly, it was a 7-2 decision in Tinker. The dissenting opinion came from Justice Hugo Black. And in Black's dissent, he really kind of said, students are sent to school to learn, not to teach. And the First Amendment right really is to express, does not grant a right to express opinion at any time, and feared that the ruling would encourage students to defy the authority of school officials. So Black's opinion, of course, comes in the time of the Vietnam protests. It's at a time where there is concern about what does that look like. And so you have now that material substantial disruption becoming sort of the standard for when do school districts intervene. That is where 159 is very different than the current law, because it adds a new element to the law. It adds intentionality, that somebody must intentionally violate the law to have an intention of disrupting the operations of the school. And so the intentionality test is a significant change in the administration. So we think about this really of then, okay, so how do school administrators administer the existing law? When I used to teach school law, my favorite way to talk about this was to talk about T-shirts. T-shirts are a great way to talk about how do we deal with students and their expression of speech and how they want to express themselves. And so if we have a student who wears a T-shirt that says, "Let's go Brandon," Let's Go Brandon by itself are just words, but it's a euphemism. It has other meaning behind it. And a school administrator might today say that there is a reasonable belief that that would cause disruption, and they could tell the student, you can't wear that t-shirt in school. That's going to cause disruption. This law would change it to say that there would have to be an intent for the student to be disruptive. And they would have to have that intent of causing disruption in the school. Now, that's fine for a high school student, but what about the elementary student? What about an elementary student who wears that same t-shirt to school? How would administration be able to ascertain the intent of that elementary student? And you can go beyond that Let's Go Brandon. Maybe somebody likes that phrase, thinks there's no problem with that. But if something were to say truck frump, also offensive, but something that potentially could not be limited. And we move on to that discussion around other symbols or other words. And there was mention of the swastika. I don't think that this actually limits swastikas or ISIS flags or occult symbols unless we go through that same intentionality sort of test. There have been some arguments of what has been called a true threat. But again, the true threat requires the intentionality sort of estimation. And I think that's why this law is different from current law and how that current law would play out. I think you've also talked about some of the other areas that we have concern with the law when it takes away existing administrative remedies. So when you talk about existing remedies such as the Governmental Claims Act or a process that allows for dispute resolution, this removes that sort of approach. It also has the mandatory $5,000 payout and attorney fees. Those are concerning because typically those are at the discretion of a judge. So I think our concerns are really how this impacts the administration of the law. Certainly, you've talked about the challenge of instructional time and the challenges that that presents. But one of the things to keep in mind with that is just last year, there was a law that passed that said that a teacher shall not require instruction in essentially divisive concepts. So if those divisive concepts are brought up by the student, the navigation of that by the teacher now becomes difficult between their responsibility not to instruct on the divisive concept and the student's right to bring forward any opinion regardless of how that opinion might cause disruption. So, Mr. Chairman, I think that there are good discussions to have around student expression, student rights of free speech, but I don't think this law offers an appropriate vehicle to them. Sometimes we say, how can we fix it? How can we make this bill better? Mr. Chairman, I don't think that this is one that can be. I just stand in opposition to it. And the last thing I think that I would add as a thought is I think when we look at other situations, contexts where students across Wyoming maybe have felt limitations on their expression, I think it's very important to ensure that we know the full story on those. That it is permissible under the current law to require all clubs to go through the same process in establishing a club. This law wouldn't change that. All clubs would still have to follow the same process. Failure to follow a process might result in the denial of a club. But once a student has appropriately completed that process, then students are generally allowed to establish their clubs, do have their clubs, and the district acts with viewpoint neutrality. They allowed the clubs from whatever perspective that exists, and that is the way that it is today. With that, Mr. Chairman, I'd be open to question.
Mr. Farmer, thank you for bringing up Tinker. I noticed the same thing on page 6. There's really three bullet points here that that fall under the, I guess it says, nothing in this section shall be construed to prevent a school from prohibiting or limiting or restricting as long as one of these three are met. One of them is somewhat the Tinker test. You pointed out correctly that intentionally is not part of the Tinker test. The Tinker test is, does it materially and substantially disrupt? What I also find really interesting is actually Romanet number 2 above seems to actually eviscerate the Tinker test. So while this bill is attempting to protect First Amendment rights, it actually is a little more restrictive than Tinker when you go and you look at Romanet number 2. And I don't fully understand it, but it seems to say that if the speech is severe, persuasive, subjective, or objectively offensive, then it can be restricted. And that also flies in the face of Tinker.
Mr. Chairman, I would certainly agree with that. Once again, causing confusion, requiring school officials to wait and see what the impact of speech is before acting, and then having to make some kind of analysis by individuals who may not have the legal acumen to judge those sorts of things in the present moment.
Any other questions for Mr. Farmer? Shirley, I see you working that language over there.
Yes, Mr. Chairman, but Mr. Farmer is starting to persuade me that we need the bill.
Okay. All right. Next up.
Mr. Chairman, members of the committee, my name is Tate Mullen, Government Relations Director for the Wyoming Education Association. I would like to first start off by saying that schools are an amazing place where our students get to broaden their horizons, their understanding of the world through exposure to diverse ideas, ideologies, and topics. That being said, again, there's a lot of this that Brian has already covered in that our First Amendment right to free speech within the U.S. Constitution and Wyoming Constitution is already covered. I share some of the same concerns. So if you go to, talking about the legal acumen to interpret that new test outside of Tinker of intentionally, that interacts with page 4, lines 6 through 10, and your concern of during instructional time. So how is an educator, I don't know the last time that anybody set foot in a middle school classroom, but that classroom management is incredibly difficult. And there was a reason that during instructional time was left out of those standards in Tinker. We have added that. We have expanded that here. So how is a teacher in a large middle school classroom supposed to have that legal acumen to determine what intentionally is? So we would also like to see the language on during instructional time removed if you were to proceed with this bill. Additionally, the language on page 6, and I'm pleased that this was brought up for discussion as well, the lines 2 through 5, it does seem far more restrictive. I appreciate the good Senator Rothfuss for pointing out the subjectively piece. That language is problematic. Ideally, again, we absolutely support student expression. Students in our schools have the right to express themselves. There are time, place, manner components to that. And what we have in current case law works for our students. I understand that there are going to be instances where there might be a perception that somebody has violated somebody's First Amendment rights, but we do have remedies in place. We would ask that this bill not be moved forward, but if you did, the suggestions on removing the during instructional time as well as language on 6 lines 2 through 5 and the intentionally standard would be preferred. So with that, I'll stand for any questions.
Questions for Mr. Mullen? All right, thank you.
Mr. Vice Chairman, Boyd Brown, Wyoming Association of School Administrators, Executive Director. They've covered most everything. Again, one of the biggest concerns for us is that it does include instruction time, which you guys already visited about. I think the issue of trying to determine intent gives us a problem for not only teachers, but administrators. And again, I would say this looks like or feels like it gives or encourages people to go to the court rather than solving the problem at the lowest level. So again, if we're looking at doing something like this, opposed to the bill in the current form, and would think that it would make a good interim topic if we wanted to do something like this. And again, I think most issues get solved, not by taking them to court. So with that, I would answer questions as well.
Any questions for Mr. Brown? All right, thank you for your testimony. Madam Chairman, do you want to take control of the ship?
No, keep going.
Okay.
You're doing a good job.
All right.
And I apologize. My bill across the hall took a little longer than I thought. So thank you for taking over.
You bet, Madam Chairman. Any other associations wishing to testify on this bill? If not, we'll move into general public comment. General public comment. Good morning, welcome.
Good morning, Madam Chairman and members of the Senate. My name is Kylie Wall, and I am a high school senior here in our lovely state of Wyoming. I am here today to support House Bill 159 because I experienced what happens when student rights depend on discretion instead of clear law. I followed the correct process to start my Club America chapter at my high school. I sought approval, worked with my faculty sponsor, and after lots of resistance, our club received a formal authorization. On paper, my club was treated the same as every other student organization. In practice, it was not. Once my club became visible, and once it was associated with a viewpoint that made some people uncomfortable because of its political reputation, many restrictions began appearing that were never applied to other student clubs. I was told I could not speak to the media, even on my own time outside of school as an individual. I was directly told no from attending a private after-hours event as an individual citizen. I repeat, not as a school club member, but as a citizen on my own time. This was directly a suppression of my First Amendment right. Materials that had been approved by school admin were removed and covered by faculty in the building. Complaints that we had made were acknowledged, but there was never an absolute resolution. And there was no enforcement for faculty and students to treat our club like other clubs. As the weeks went on, the situation escalated. My club was singled out repeatedly. Flyers were continuously torn down. Profanity was written all over our club flyers. My club members were mocked and intimidated for being associated with the club. I had people threaten me and attempt to cause me physical harm for starting the club. Eventually, a message appeared on campus carved into the paper towel holder in the bathroom, calling for death to the organization my club was affiliated with. At that point, the situation was no longer about disagreement, it was about safety. I reported what was happening through the proper channels. I documented incidents, I followed district policy, I involved my parents, and I even involved local authorities. What I did not receive was clarity, protection, or reassurance. I was told only that it was being handled, not that I was safe, that my club members were safe, not even that this hateful behavior from others was not tolerated. HB 159 exists to prevent exactly this kind of situation. This bill does not create special privileges, it creates clear standards. It ensures that once a student organization is approved, it cannot be quietly restricted or selectively enforced against. Because of its viewpoints, it ensures that student speech is treated consistently and ensures that harassment and threats are taken seriously, regardless of who the target is. If HB 159 had been in place, what happened to me would not have escalated the way it did. There would have been clear boundaries instead of shifting rules and accountability instead of silence. No student should have to endure intimidation just to participate equally in school life. And no family should be left wondering whether their child is safe because the system failed to act. My mother shouldn't have been anxious to have to send me to school every day because she was worried for my safety. What this did to me personally is something I don't want minimized. The situation mentally drained me. I became afraid to go to school, afraid to register for my next semester classes because I was afraid of teacher retaliation that I had already started receiving for my viewpoint. I lost friendships, I became isolated, and felt unsafe in a place that I'm supposed to feel protected in and supported. What hurt most was realizing that even after reporting everything, there seemed to be no concern for my well-being or the safety of my club members. I'm asking you to please support House Bill 159 so that student rights are protected by law and not left to discretion. Thank you for your time, and I'm happy to hear any questions.
Thank you, Ms. Wall. Before I get into questions, I just want to say thank you for testifying. It's not an easy thing to testify in front of a legislative committee. I imagine it's probably your first time, or did you testify on the House side?
No, this is my first time.
Okay, well, you did a great job, so thank you.
Thank you.
Senator Scott.
Mr. Chairman, question, because it's been a while since I've had a high school student at home. And I didn't understand the name and the nature of your club.
Ms. Wall.
Yes, thank you. So my club is a Club America chapter. We are affiliated with the Turning Point USA. It is a civics and government club. We are nonpartisan. But yeah.
Thank you. Any other questions for Ms. Wall? All right, again, thank you. Ma'am, you're next.
Go. Good morning, committee. Chairman Schuler, committee members, my name is Laura Pavey, and I'm speaking today on behalf of Moms for Liberty chapters across the state of Wyoming. We are here in strong support of HB 159, safeguarding personal expression in K-12 schools. At its core, this bill is about fairness and clarity. Students in Wyoming schools should be free to express their religion, political, and ideological views without being treated differently because of what their views were. HB 159 does not create unlimited speech. It does not override existing constitutional boundaries. The schools retain the authority to prohibit expression that is, Schools retain the authority to prohibit expression that is unprotected underneath the First Amendment, that the material and that material that substantially disrupts school operations or that rises to the level of severe pervasive harassment that denies another student access to education, those guardrails remain still in place. What the bill does require is that viewpoint neutrality. If one student group is permitted to meet, others must be treated the same. If certain messages are allowed on clothing or in assignments, policies must be applied consistently, regardless of the perspective expressed. Rights in a civil society are not absolute. They exist within defined limits, and where they infringe on the rights of others. HB 159 reflects that balance. It protects student expression while perceiving the school's ability to maintain order, safety, and equal access to education. Schools prepare students for citizenship. This preparation includes learning how to express their ideas, organize and shared interests, and engage respectful and in differing viewpoints. Those lessons only work if rules are clear and applied consistently. HB 159 provides clarity. It protects students, guides administrators, and reduces unnecessary conflicts. We urge you to pass 159 to ensure that every student, regardless of their viewpoint, is treated equally under the rules. And if I could just add one more piece about the educational instructional setting, say the students are watching CNN 10. And this is about their current events, which is in our state standards for social studies. Say they watch CNN 10 and it is pushing, the news is pushing one certain viewpoint. If a student in that classroom does not agree with that viewpoint, they should be able to say in class their opposite view of what occurred or what had taken place. Say if they are in science class and they are talking about reproduction, and a student talks about how they feel like a fetus is a life, is a human life. Those things should be able to be talked about in an educational setting. And with that, I stand for questions. Thank you so much.
Committee, any questions? I appreciate your testimony. And you
Thank you.
came all the way from, was it Green River or Rock Springs?
Yeah, I'm here from Green River.
Green River, okay.
I'm going to try to stay until Monday.
Well, you might as well just stay a whole nother week. We've only got a week left.
I miss my kids and my animals.
I understand.
Thank you so much.
Appreciate you.
Thank you.
Coming all this way to testify. Thank you. Is there any other testimony in the room before we go to online testimony? What do we, I don't know. Do we have a list of what we have online? Just one? Okay. And that's Mr. Sharp?
Correct. I have promoted him to panelist. He should show up in just a second whenever he's ready and able.
All right. Mr. Sharp, welcome to Senate Education.
Morning, Mr. Chair and members of the committee. Again, I'm Matt Sharp. I'm senior counsel here today on behalf of ADF Action. Our organization regularly advocates for free speech, religious liberty, life, and the family. We analyze proposed laws to see their impact on constitutional freedoms. And our sister organization, Alliance Defending Freedom, routinely represents many young students in clubs across the country whose rights have been violated to speak, to share their views, to form clubs. I wanted to just briefly walk through some of the questions and comments that have come up. We've litigated a lot in this space, very familiar with the case law and sort of the reasoning behind some of the specific choices made in the wording of this bill. So early on, we had a question about similarly situated students. And the overarching principle of this bill, and this is reflected in on page 3, there at lines 7 through 8, is protecting students from discrimination when they engage in expression at the same time, place, and manner, and to the same extent that similarly situated students may engage in it. That's kind of the key term, because what we're saying here is when the school makes a decision to allow other students to speak, to express, for clubs together, all we're saying under this bill is everyone gets treated the same. Every viewpoint is allowed to the same extent that others are allowed. Now, a school may say, we're not going to create a forum. We're not going to have a classroom activity where we open up discussion. And if that's the case, then no discussion would be allowed. So we brought up the idea of similarly situated students. So as we said, if a teacher says for students in one specific class, we're opening up and having a class discussion, that doesn't mean other students can come into the class and engage in that because they're not similarly situated. They're not enrolled in that class. You could also have a situation where a school says, we're going to have a senior day and we're going to have an opportunity for seniors to give up and give sort of farewell messages. Well, a junior or sophomore or freshman is not similarly situated, so they wouldn't have rights under this to be able to engage in expression. So that language is simply saying that schools can put guardrails about who can speak in certain circumstances, and nothing in this prevents schools from being able to say, at this time, we're going to have this particular group of students, whether it's in a particular class or in a grade level, give them an opportunity to speak, but that doesn't mean we're throwing open the door wide to everyone to speak. There was also the discussion about instructional time and why that's included. Well, for a couple of reasons. Number one, there are times when a teacher maybe it's a free period, maybe they finish their activities for the day and the teacher said, hey, everyone, I'm going to give you all some free time. You're free to gather and chat with friends. Well, if a group of students wanted to, in that moment, gather together and pray, again, the teacher has opened it, the teacher has allowed it, not required, but the teacher's allowed it. In that moment, if the teacher is allowing other students to get together, to talk, to congregate, as it talks here, organizing, getting together, this bill simply says that to the same extent the teacher allowed one group of students to do it, other groups of students may be allowed to do it in that classroom to pray, to share their religious viewpoints. So the reason instructional time was included is to recognize that if a teacher creates that opportunity, again, the teacher doesn't have to, but if he or she does, it gives that same opportunity to others. And that's actually language that is included in the guidance on constitutionally protected religious expression at school that the sponsor mentioned. There's a reference in it to said students may engage in prayer or religious expression during instructional time to the same degree that they may engage in non-religious private expression during such time. So again, this is just bringing in that standard to say at any point when a teacher opens up discussion, we treat every student the same without regard to their viewpoint. There was also some discussion about the exceptions that are built into this, the things that schools can restrict without violating this. And specifically, the three exceptions are: one, schools can restrict speech that is not constitutionally protected, that is not protected by the First Amendment. What does that include? That includes obscenity, that includes true threats, fighting words, other things like that. And so with the example of a student bringing a swastika or Confederate flag, those are things that the courts have said, when you show up at a school environment with that, those are fighting words. Those create sort of a environment that fights can break out, and schools can restrict that. So this is codifying the ability of schools to not allow unprotected speech like that. The second one that was brought up was the reference to the harassment standard. And so this is on page 6 at lines 2 through 5. Talking about expression that's unwelcome and so severe, pervasive, and subjectively and objectively offensive. That language actually comes directly from the Supreme Court, from a case called Monroe versus Davis that dealt with harassment in the school context. It was actually a very tragic case where a school was ignoring evidence that one student was harassing another, was engaging in a pattern of severe, unwelcome, subjectively and objectively offensive speech, and the school ignored it. And the Supreme Court said, you violated your obligations under the law by not addressing that. So this is actually codifying that ruling from the Supreme Court, saying schools, you can and should address harassment that's happening in your schools. And this is the language that the Supreme Court and lower courts have adopted, setting that out, what schools should already be doing. This is also the same thing that applies in the Title IX context, dealing with potentially sexual harassment at school. So again, this is just codifying Supreme Court precedent. There's also going down on the use of the Tinker test. This is on page 6, lines 7 through 12, and specifically asking about the references to intentionally. The reason that's inserted is because, yes, Tinker did set that framework of materially and substantially disrupt, but we also look at what has the Supreme Court and other courts said about Tinker since then. And that's where the intentionality aspect comes in. A few years ago, there was a case at the U.S. Supreme Court dealing with a cheerleader who was frustrated because she didn't make the JV cheerleading team. And she goes on one of the social media platforms and kind of mouths off. And the school said, oh, this created a disruption at the school. We're going to punish you for that. We're going to discipline you for that. And the Supreme Court in that case said, you violated the student's rights. And talking about the Tinker test, said the student was not directing this at the school. The student was not intending to disrupt the operations of the school, was not intending to create a disruptive environment in the school. This was a private conversation that the school was kind of using to try and punish her. And so that intentionality aspect, the reason that's in there is because since Tinker came out in '69, the court has provided greater clarity to make sure that schools don't take that too far, where they try and justify it when the student was never intending to disrupt, was never intending to stop the school operations. So again, this is reflecting what the courts have said about the appropriate sort of boundaries of the Tinker test and how schools can apply it. Finally, I know there's some questions about sort of the legal remedies, the $5,000 in damages. It's hard to put a price tag on the loss of our constitutional freedoms. How do you put a dollar amount when a student like Kylie is denied the ability to start a club? How do you put a dollar amount when a student's told you can't pray here, you can't share your views? So part of this is reflecting that because we can't assign a dollar amount, we want to show that when the government violates free speech, when it censors or silences a student, that there is a concrete harm. And so this is meant to reflect it. Again, there's no magic to the 5,000, but just a reflection that our free speech rights are very precious. What we're trying to cultivate in these students is so that one day the debate and discussion that happens in their classroom, that they may one day bring that here to the legislature and engage in the same type of discussion and advocating their views before committees just like this. And just like this committee is welcoming different viewpoints, different opinions, while still setting guidelines. You know, we can't disrupt, we can't engage in profanity. We want those same protections to extend to our students as we're cultivating and preparing them to engage in discourse and dialogue as they head into adulthood. So again, what this bill is simply doing is taking all of the existing legal precedent, putting it in a very clean package so that rather than a school having to go and research all of the case law and figure out what the courts have held, taking that precedent, putting in a simple, clear bill so that students know their rights. Schools have clear guidelines, not only of what they must allow, but also what they can appropriately restrict, and ultimately protecting students' rights to engage in discourse and dialogue in the classroom and throughout the school. Thank you, and happy to answer any additional questions.
Yes, Chairman Schuler.
Thank you, Mr. Chairman. Yeah, question, sir. On page 6, you talked a little bit about concrete harm. And that was one of the questions I had on this bill is how do you prove that someone has truly been harmed or had their rights violated? How do you prove that concretely?
Mr. Sharp.
Thank you, Mr. Chair. And that is one of the challenges. How do you prove a dollar amount? How do you prove this is what it cost me? You know, if we're talking about a personal injury matter, we know what the doctor's bills are. If we're talking about a breach of contract, we know the loss of business. When it comes to First Amendment rights, it's hard to put a dollar amount on it. So that's part of why that 5,000 damages is in there. But when it comes to sort of proving the harm, what the courts look at is, was the student's right to expression? Were they wanting to express themselves, engage in expression? And did the school take some action that censored or silenced that expression? So that's the harm. And then the court looks at, just like the bill does here, nonetheless, was the school allowed to do so? Was the student harassing another student? Were they disrupting the classroom? Was it unprotected speech? So this bill is actually walking through the framework of what a court would look at in analyzing these things. What schools should look at is a student wanting to express themselves, are they doing it in a way that other students are allowed to? So again, if this teacher says, we're not having discussion in the class today, nothing in this bill gives a student the right to speak, because nothing in the First Amendment gives a student a right to speak. When the teacher says, we're not having discussion today, we're just going to focus on the classroom activity. Same thing if a school says, we're going to have a strict dress code. We want everybody to wear, blue polos or something like that. Again, this bill clearly says only to the extent that other students are allowed to express their viewpoints on clothing is a student allowed to express their religious or political views. So ultimately, this boils down to, are students expressing themselves? Did the school do something that silenced that expression? Is the school allowed to do so under the law? And if the school's not, then this gives that legal pathway for students' rights to be upheld.
Mr. Sharp, on page 6, subsection G, it says that any person or student club or organization that is harmed by a violation of this section or whose rights under this section are violated shall have a cause of action. What is the difference between being harmed by a violation of this section and having your rights of this section violated? So there's two different clauses there, and they seem duplicative, actually. So I'm not sure that language is completely needed, but maybe you can help me understand why that exists.
Sure. So I think it's meant to address maybe two types of fact patterns. So, for example, let's say you've got a situation like Kylie. She has a right to form a club. So to the extent that she asked to form a club and she was denied from doing so on the equal basis as others, that is a harm to her, or excuse me, that is a violation of her right. However, you may have also harms to the students who were not allowed to join that club because it wasn't allowed to form. So if you had a group of students joining together to say, Kylie wanted to start a club, she was denied the right to do so. We wanted to be part of that club and we were harmed because Kylie's right was violated. It would allow them to sort of join together. But I would say, if the committee just wanted to focus on violations of rights under this bill, that would be fine as well. We just wanted to make sure that we were capturing sort of all of the instances where a student, maybe their rights weren't directly violated. They weren't the one who was told no, but nonetheless, they were harmed because the club they might have wanted to join or be part of was denied as a result of the school's actions.
Thank you, Mr. Sharp. Any other questions, committee? All right, we appreciate you zooming in.
Thank you.
Is there any other testimony online? And just one last opportunity, any testimony in the room? If not, I will close public comment. Committee, what is your pleasure?
Mr. Chairman, move the bill.
It's been moved by Senator Scott and seconded by Senator Schuler. I know I have some amendments.
Yeah, go ahead.
Let-
I do too.
Okay, so the first amendment I would propose is on page 4 under Romanet 3, lines 7 and 8. I would strike during instructional time. I think it's totally appropriate to engage after school and before school, but I am very hesitant to allow it during instructional time. I think that could get us into some unintended consequences.
Mr. Chairman,
Senator Scott.
let me suggest an alternative there. Take out the during instructional time and say during non-instructional time during the school day.
So take out before school and after school as well?
No.
Leave-
no, before and after are fine.
Okay,
During the school day, you want time that's non-instructional,
I
like
see.
lunchtime.
okay. I like that. Okay, so my motion would be to strike instructional and replace it with non-instructional.
We were on the same page there.
Non-instructional time. And I think you then need to add on line 8 during the school day. So we have before school, after school, and during the school day, all covered.
So that it would read during non-instructional time during the school day?
Yeah. Organized religious, political, or ideological gatherings before school, during non-instructional time during the school day, and after school to the same extent.
That's fine with me. Does that make sense? Okay. I'll take that as the second from Senator Scott. All right. Any other discussion? All those in favor signify by saying aye.
Aye.
Any opposed? All right, that motion is carried. I have the same or similar motion, so you might, if you have a different idea on how to tackle this, on the bottom of page 4, line 21, we have during. So this is before, during, and after school, and it's the same issue. I mean, we could just move the language to during non-instructional time during the school day.
Mr. Chairman, that'd be, I wouldn't have any objection to doing that. I hadn't thought that was gonna be necessary, but it's fine.
Yeah,
That's a good catch.
okay, so same amendment. Any other discussion on the amendment? All those in favor signify by saying aye.
Aye.
Any opposed? That amendment has been adopted. On page 6, so starts on page 5. It's a list of, so it says expression that the First Amendment to the United States. Oh, let me back it up. Nothing in this section shall be construed to prevent a school from limiting or restricting speech if it falls into one of these 3 categories. That first box is going to cover the school. Any expression that the First Amendment does not protect, that gives them a lot of latitude. I think that's fine. But the next 2 give me consternation. So I'm not comfortable with the modification to the Tinker test. That's Romanet number 3. The word intentionally, the Tinker test is if it is materially and substantially disrupting the school. So I think we could strike intentionally. Does everyone feel good about that? Okay. All those in favor signify by saying aye.
Aye.
Any opposed? Did I talk too quick or?
We're basically just striking intentionally on page 6, line 7.
You got it. Yep.
Mr. Chairman,
Go ahead, Senator Scott.
what about just removing lines 2 through 4?
That is exactly what I was going to do next. Yeah,
Same here.
I
Same page.
don't have as much familiarity with the Davis case that was cited, but what I think it's a very confusing test. And for an administrator to try and interpret what is subjectively and objectively offensive is a little much. So I would feel comfortable taking it out. All right, moved by Senator Scott, seconded by Senator Schuler to remove lines 2 through 5 on page 6. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed?
And Mr. Chairman, they'll have to renumber accordingly.
Yes, and renumber accordingly. He's got that. Okay, while we're on that same page, subsection G just seems like it has duplicative language, so I would move to strike that is harmed by a violation of this section. Because that, what does that really apply to? Is it applying to subsection G? Is it just applying to it's not applying to the entire act. So I don't think that accomplishes what the drafter wanted. But, and so it would, yeah, sorry. So on line 14, that, line 15 is harmed by violation through or. Okay, it has been seconded by Senator Schuler. Any other discussion? All those in favor signify by saying aye. Any opposed? All right, that amendment has been adopted. Page 7. Romanet number 2. So yeah, the only way you fix this problem is by deleting it. The problem is the $5,000 monetary damage. I know there was some testimony about it being attorney's fees. It doesn't say that. It's damages in general. It's very unusual to have some type of provision like this in Wyoming law. So I would just strike the whole paragraph. I agree with Senator Scott.
It's another one I was on the same page.
Man, we're on fire. All right. It's been moved by Senator Scott and seconded by Senator Schuler. Any other discussion? All those in favor signify by saying aye. Any opposed? Okay, that amendment carries.
Mr. Chairman,
Yes, Senator Scott.
further on page 2, lines 6 through 11. Why do we need to mess with federal courts? We don't have any authority over them. Why do we need to talk about the 11th Amendment? Mr. Chairman, I move we delete lines 6 through 11.
Okay, I'll second that. I agree, Senator Scott, because based on the testimony from the bringer of the bill, she talked about how federal court is more expensive and difficult to get into, that the purpose of codifying everything in the statute was to allow for remedy in state court. So I don't think it harms the bill at all. I think that is language that we can definitely take out. Any other discussion?
Mr. Chairman, there was some discussion about administrative remedies. Frankly, I think the bill is useful because there is some possibility, and we have seen at least one instance where there was a need for having something like this, but I don't think it is frequent enough to justify a big administrative structure. I think the bill will be mostly self-executing.
Okay, let's finish this amendment real quick, Senator Scott. Is there any other discussion on this amendment?
Oh, I thought we hadn't finished.
No, I hadn't called the vote yet. Sorry. All those in favor signify by saying aye.
Aye.
Any opposed? Let me just take another look. If anybody else has anything else.
I don't see that we need to change the title any. Have I missed something?
Let's see. Specifying protections for speech and expression by students at public schools. No. Nope, I don't think so. We left in the amending Governmental Claims Act. There's a cause of action still. And specifying activities in which students may engage in, I think that's fine. I don't think we have any adjustments to the title. But I'm sure LSO will catch it if we're missing something.
Mr. Chairman,
Senator Schuler.
I do have some issues with, the declaratory injunctive relief. I have a tendency not to believe that we need to do those kinds of things. And so, if we move the bill forward, I don't know, I may come back with an amendment on that. Since I didn't get to hear the first part of the conversation from some of our agencies, I won't do anything with it now, but I think there might be a better way to deal with some of this, as Senator Scott mentioned. But I'm okay to just leave the rest of that alone for today.
Okay, I will say the one thing you started to talk about this, Senator Scott, but the one thing I really do feel like the bill is lacking is that administrative process. I wish, I've looked at some other legislation. We did this in the parental rights legislation last year, I think. It was Senate File 9. And then we provided for the parental rights bill an administrative process that a student and a parent can go through before they seek remedy from a court. I would love to have something like this in this bill that allowed for a process to try to mitigate before they end up in court, because otherwise we're just going to start costing our schools money, which is costing us money. So the more we can avoid a lawsuit, I think the better off we are.
Mr. Chairman, I expect the natural process is going to be that the first thing that the student and the parents are going to do is complain to the principal. And I think you're going to have an informal process. And this, with this in the background as a potential remedy, I think we're probably all right without having to have a big formal structure.
Okay, well, I will, I think I don't disagree entirely, but I don't have an amendment now because it would be pretty substantive. So I'm going to continue to stew on it and maybe something will come on the floor, but.
And Mr. Chairman, I would agree with you. That's exactly where I'm at.
Okay,
To me, there's always a process you should follow first before we ever get to a point where we start throwing lawsuits left and right. And then obviously, if we don't feel like our voices are heard, and, action's been taken, then I don't have a problem with the rest of the bill. But the way it is now, without that, I would have a hard time.
okay, we'll definitely see if we can work on that. Any other amendments to this bill? Any other discussion on this bill? I think we have definitely
Worked
it over. Felt like I was in Judiciary Committee. Good job, committee. All right. With that, we please do a roll call vote on House Bill 159, safeguarding personal expression at K-12 schools.
This is a roll call vote on House Bill 159 as amended. Senator Brennan,
Senator Brennan left an aye vote.
Senator Olson,
Aye.
Senator Rothfuss,
Senator Rothfuss left an aye vote.
Senator Scott,
Aye.
Chairwoman Schuler.
Aye.
Mr. Chair, you have 5 ayes.
Very good. Thank you. And that's the only bill we have for the day. So I guess we're adjourned.
And thank you, Senator Olson, for taking over. Appreciate it.